All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable William D. Palmer presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Amen. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Torpy. To my left is Judge Cohen. We have both criminal and civil cases on the docket today. 15 minutes per side on the criminal cases, 20 minutes per side on the civil cases. We may shift the order of the third case and the fourth case if the lawyers are here in time for the third case, because there'll be a panel change. But after the first 2 or 3 cases, depending on when lawyers show up, we will take a morning break, and the lawyers are invited to join us for coffee in the lawyers' lounge if they would like. The first case is KLADIVKO versus State.
Morning, Your Honor. Yeah, I'm Robert Bernard. I represent the appellant in this case, Mr. KLADIVKO. And this is an appeal from denial of a 3.850 motion in front of the trial court. The original case was a murder charge, second-degree murder. Defendant, or the appellant in this case, Mr. KLADIVKO, was convicted in 2008. There was an appeal that was affirmed. The appellant in this case was 83 at the time of the homicide back in 2008, and the victim was 62.
The trial lawyers testified at the hearing, right?
In the 3850 hearing, both trial lawyers testified.
And the judge believed what they said.
The judge
believed them.
He did.
To the extent that there's any conflicts in the evidence, the judge resolved them in favor of the state, right?
The judge resolved them in favor of the state. I think what he did was, I don't think he applied the test correctly. The first issue and the second issue both deal with the Strickland decision, and I think the effective assistance of counsel test in Strickland, which...
Well, I mean, this is a case where the trial lawyers, it was a conscious omission. In other words, they made a conscious judgment not to seek out a forensic expert, and a conscious decision not to call these witnesses as to the peaceful and loving relationship.
Judge,
to what extent are those strategic decisions?
Well, Judge, I don't think you can say those are strategic decisions.
Taking, for instance, the second one first, of the relationship, there was conflicting evidence as to what the nature of the relationship was, and if the defense had chosen to present witnesses, the state would have been allowed to bring the other witnesses in, testimony, evidence that would not otherwise have been admissible. Why isn't that a strategic decision?
Judge, in our investigation in interviewing those witnesses, the neighbors that were the 2 neighbors that one they had dinner with, another one having redesigned the house, and then the lady that came in the day of the homicide and did the house investigation, they all would have been very important witnesses, which would have attacked the state's theory of the prosecution, which was that KLADIVKO had set up the scene.
The point is, Mr. Bonero, that there were other witnesses that would have testified contrary to that these lawyers were aware of at the time that they had to make a decision as to how they were going to proceed at trial.
Judge, that's the problem with the conflict, is that they've never identified these other witnesses.
Well, but they said there were other witnesses, and the trial judge believed them. Aren't you stuck with that?
Not really, Your Honor, because
you want us to reweigh the evidence and decide that when the lawyers testified below that there were other witnesses, that they must have been lying?
Well, I think what this court has to do is determine, to make sure that the trial judge's decision was based on substantial, competent evidence, but that the legal review is de novo, and I don't think he applied the right test here, because
But
those
if the lawyer says that there were other witnesses that would have provided unfavorable testimony, and the lawyer can't identify who those witnesses are, that goes to the weight of the evidence. It doesn't go to the sufficiency of it, right? I mean, the trial judge could still believe the lawyer, right?
Judge, there was really no evidence indicating there were other witnesses that would have contradicted the evidence that
The lawyer said there were other witnesses that he uncovered, right? Or am I mistaken about that? Didn't Mr. Spivey testify that, they had located adverse witnesses?
He said that they thought there would be some adverse witnesses, and he didn't want to open the door to that. But we never saw any of that evidence. The only evidence we had in the affidavits that we used to support the motion, the 3850 motion, we didn't uncover any witnesses that would have testified contrary to the fact that they had a good relationship.
Well, let's get. I don't want to use up all your time on that. How about get back to your issue about the forensic pathologist?
As far as the forensic evidence is concerned, Your Honor, both attorneys for the appellant in that case testified that, for example, regarding Mr. KLADIVKO's wounds, which Dr. Anderson testified were defensive wounds, stated that they never actually had crossed their minds to use a forensic expert to bring in the fact that those wounds that Mr. KLADIVKO received were defensive wounds. Now, you can't say that's a strategic decision. So they never crossed their minds. Anderson would have testified that those wounds were, he didn't say that it's not possible that they could have been self-inflicted. He said it was probably they weren't. But that would have raised a reasonable doubt, because you have to remember the state's theory in this case was that Mr. KLADIVKO set up the scene after the homicide was committed. And setting up the scene by stabbing himself, putting a knife in the victim's hand, cleaning up the area. He waited 25 minutes, according to the state, before he called for 911. So Dr. Anderson's testimony would have established that these were, in his opinion, defensive wounds. And Judge, that would have gone right to the theory of the state's prosecution, that he set the scene up. And you just have to raise a reasonable doubt. And like I said, both of the attorneys said they'd never considered calling an expert to establish that these were self-inflicted wounds. And I don't see how you can say that that's a strategic decision. We set out this Douglas case in our brief on page 15, which is
Well, couldn't it have been a strategic decision if they knew that a witness couldn't say definitively that they were defensive wounds? You yourself said the witness would have said they still could have been self-inflicted, but it's more likely than not that they weren't.
Judge, that's all I need to do is raise a reasonable doubt. And in this case, they didn't raise any sort of doubt regarding the defensive wounds, other than Mr. KLADIVKO's direct testimony. So the state, they didn't do anything to fight against the state's evidence, other than putting on Mr. KLADIVKO and then using their own talents to say, well, we're going to create a reasonable doubt just regarding the state's case. But they didn't even cross-examine the state's experts regarding some of these issues on his wounds. And one of the other things is that Anderson would have testified, in his opinion, the 911 people, when they came, the responding paramedics said in the medical reports he was apneic at the time. Anderson says you can't fake being apneic because if you try to hold your breath, you're going to have spontaneous respirations. So that was another issue, because Dr. Anderson says that's something you can't fake. Again, he could have supported that testimony. That would have raised another reasonable doubt. The other thing is Anderson would have testified, Dr. Anderson would have testified regarding the victim's injuries. There was some 18, 19 wounds. 2 of the wounds, according to Dr. Anderson and the state's expert, were fatal wounds. They were deep wounds which caused the death. Dr. Anderson testified the other wounds were superficial, not inconsequential. That's not what he's saying. He's saying they were superficial and that they didn't cause death, and which would have gone to the fact that the state's theory, again, was that Mr. KLADIVKO was in a homicidal attack, homicidal rage, and that's why they had all these injuries to the lady. And Dr. Anderson would have said there was only really 2 killing blows. The rest of them were like defensive blows or slashing out.
I didn't understand the significance of that testimony.
Doc, I'm sorry?
I don't understand the significance of that testimony.
The fact that those 2 wounds, as opposed to all the other wounds, were only homicidal.
Explain it to me like I'm a 3rd grader.
Because the states argued in their case that Mr. KLADIVKO was in a homicidal rage, and he stabbed this woman 18, 19 times.
Right. He did.
And that's
there were that many stab wounds,
That's
right?
correct, Your Honor. Only 2 of them were fatal, according to both the forensic experts.
Right, so take me to the next step. I mean,
The next step would have been that the state argued that this was a homicidal rage, that she was leaving him, and he went crazy, and he stabbed her to death.
Okay.
It's 18, 19 times. Dr. Anderson would have testified this was not a homicidal rage.
What's your argument in closing with that evidence?
My argument would have been to take that fact that those were only 2 stabbing wounds, the fact that the state didn't...
Well, no, there weren't more than 2 stabbing wounds. There were about, 16, 18 stabbing
Correct.
wounds.
2 of the
And what
wounds...
you're doing is you're just using a definition of superficial, contrary to its normal usage. Superficial to you means would not have produced death. But
Correct,
that
Your
doesn't
Honor.
mean that there weren't 18 stab wounds.
Well, that's what I agree with that, but
What is the
Anderson
argument? I don't understand the argument. That he
argument
didn't
would have
intend
been-
to kill her? That he did not intend to kill her because they
Correct,
were
Your
all
Honor.
superficial wounds?
If you'd have taken Anderson's testimony, which would have been that these were the wounds that KLADIVKO had on him were not self-inflicted, that there was only 2 stab wounds that caused death, that the paramedic who testified that the victim had been dead for over 25 minutes, and Dr. Anderson said you can't establish that time of death by touching a corpse to tell them how long they've been dead. And the fact, the state's theory was that during this period of time, it was over 25 minutes, that he set this scene up.
But wasn't your client's testimony consistent with the fact that there had been that delay between the death and when the folks arrived? Wasn't that consistent with other testimony in the trial?
Well, his testimony was that Judge, he doesn't really know the time frame because he was kind of in shock, and once he called 911, he passed out.
Was there other testimony supportive of the fact that there was a time lapse between death and when
the only time frame established as to the time of death was this testimony used by the paramedic that came in and said that his body felt cold, and the time period between the 911 call and when they arrived was 25 minutes, and that the body had been dead longer than that. And the state used that in their final argument. So that would have been another reasonable doubt, Your Honor, Judge, that they would have been able to establish that they didn't establish the time of death.
Well, the defendant gave some testimony that he had done some things after he discovered the body and before he called 911, didn't he? Didn't he say that he went to the kitchen or something?
Judge, he was kind of like wandering around in a daze. The state's theory was he wasn't really wandering around. He had put the knife in her hand.
Right.
The other thing about the defensive wounds in his arm was that Dr. Anderson would have testified that if you had done some forensic testing regarding the sandals that she had on her feet, there was blood on those sandals. We don't know, it wasn't established whether the blood came from the victim or if the blood came from Mr. KLADIVKO. If it had been from KLADIVKO, it could have argued that it came during the struggle, not after she was dead and then she was laying on the floor. There's no evidence regarding that. And I think that which goes back to the witnesses that we talked about originally, that the 3 witnesses that they state that the defense didn't call, is that the lawyers have a duty, and we set that out on that State versus Law case, to investigate and present any and all evidence that supports the defendant's hypothesis of innocence, and they didn't do that. They never, and if you just take their testimony the lawyer's testimony that they never considered calling a forensic expert to support their defense, that just didn't cross their mind, you can't say that's a strategic decision. And that Judge, and the other thing about credibility, let me just point that out before you tell me to sit down. On page 18 of the brief, we set out this case of Tyson case, which deals with the credibility because the judge had a problem with Dr. Anderson's credibility. That case says that a post-convictions court capacity to determine the credibility of a witness is limited to determining whether the failure to call a particular witness prejudiced the defendant. The post-convictions court's role is not to examine whether it believes the evidence presented at the evidentiary hearing, rather the contradictory evidence presented at trial, but to determine whether the nature of the post-conviction evidence is such that a reasonable jury would have believed it. That's all the judge needs to decide.
Let me, as a proposition of law, you have a witness that recants, and so the lawyer brings it as a 3850. Are you suggesting that the trial judge can't make a credibility finding?
If the on 3850 you'll bring in that's newly discovered evidence, Judge. That's a different test. This is not newly discovered evidence. This goes to a newly discovered evidence. You make a credibility test. That's not the case here. This case here deals with the fact that they didn't present any evidence that goes to back to the Strickland standards different.
The defendant testifies and his lawyer testifies, and they're in conflict. The judge can't make a credibility finding. Is that what you're suggesting?
If the lawyer testifies
and the client testifies, and they're in conflict, what do you think? He
can make a credibility finding based upon whether or not there's substantial competent evidence to support their testimony, but not that type of credibility, because that's not what the issue is. The issue is whether or not the evidence was something that the jury would have accepted. That's the issue on a 3850 dealing with ineffective assistance of counsel, as opposed to newly discovered evidence, and that's not what this is. This is not newly discovered evidence. The test on the Strickland case is counsel's performance fell below the standards reasonably expected of competent counsel, and that the omissions prejudiced the defendant such that the confidence of the outcome of the case was undermined. And that's what we have here.
Your time has expired. In fact, you've gone on.
Thank you.
Thank you.
May it please the Court, my name is Chris Davenport, and I represent the state of Florida. I think this is clearly a matter where the trial court's factual findings are fully supported by the record. He made a credibility determination that this pathologist, as soon as he said, yeah, the victim's wounds were superficial, he said, it was hard to believe pretty much anything he said after that. But as far as even if you believed everything he said, it wouldn't have changed the result of the trial. It didn't. The failure to call him didn't render his trial fundamentally unfair. And it was a matter of strategy. Mr. Spivey testified that it was a self-defense case. Of course, a pathologist, the state's pathologist, couldn't say who the aggressor was, and that was what the issue was at trial. Calling another one wouldn't have been able to testify to that either. He said the defendant's story matched up with his wounds, and it made perfect sense, and a pathologist wouldn't have helped that. And he specifically said he considered this in hindsight after he got the 3850, and no, he still wouldn't call one because this isn't the type of case where a pathologist is going to make a difference. This was a 20-year lawyer, board certified in criminal trial work. He said these pictures showed the most horrendous butchering he'd ever seen. So the pathologist calling these wounds superficial would not have helped the defendant with the jury. As far as these witnesses who would have testified that their marriage was so spectacular, there were other witnesses who would have testified that the defendant was abusive to her, and the reason we don't have those witnesses is because the defense counsel kept that out. Again, a strategical decision to not open the door to a bunch of testimony about the state of the marriage, which obviously didn't end well, no matter how it was in the public. So the defendant has failed to show deficient performance or prejudice, and the trial court's order should be affirmed. Thank you.
Thank you, Counsel. Next case